Okay, haters, can you put the podcast in session? Welcome to another episode of I Hate Real Estate with my co-conspirator, Mr. Kendall Grooms. How you doing?
I'm good. How are you?
How was Dallas?
It was great.
Yeah. Tell me about it real quick.
Well, it's always good when you win.
Yeah.
I've been to a lot of...
This is not a court case we're talking about.
No, it's a football game, Razorbacks. I'm a big Razorback fan. I've been to a lot of away games and ultimately quit going because it's just miserable when you go 6 hours, 10 hours, plane flight somewhere, and you get beat by 3 touchdowns. It's not fun. And it does happen on the road oftentimes, but
not this year.
Not this week. This week it was fun.
I like how I just pushed all the way through the year right there. Tell me real quickly, though, in Jerry's world with the giant TV and all these people, could you hear the hog call?
Yeah.
Was it like roar?
We were actually right above the band. We were the row above the band.
That
so
is
it was fun.
So
the kids
cool.
liked it.
I was about to say your kids probably loved that. So, well, that's how we know you're a good person. You're a Hogs fan. So those of you who are tuning in who are not Hogs fan, keep listening, but you suck. Anyways, today we're going to talk about one of my least favorite subjects, but one of the biggest areas of mistakes for both agents, owners, brokers, and something that probably comes across your desk more often than anything else, or at least probably as much as complaints, is going to be property management. I'm sorry, I didn't know we were allowed to cuss on the show. Property management. So real quick, I'm going to open it up with reading to you the first paragraph of the Property Management Self-Evaluation Guide from the Arkansas Real Estate Commission. If you're managing property and you haven't heard this paragraph, that is a problem. It says property management activities include the leasing, managing, marketing, and overall maintenance of the property of others. Property management involves more bookkeeping and paperwork than most any other area of real estate practice. AREC investigators continue to see deficiencies during office examinations of property management transactions, and that's why this guide was developed. So we'll walk through it, but go ahead and introduce me to, so far, your experience with property management.
Well, first off, what that means is you have to be able to account for every action you take on behalf of someone else for their property, and every penny that you collect, spend, use for advertising, rent, maintenance, repairs, whatever it may be, you have to be able to account for every penny every day.
Yeah.
And that's what that means.
You thought
we have to do that in our law firm. We have a trust account where we hold other people's money. It's the same thing, except we're just holding money and providing services. We're either holding money from like a settlement or something like that we will eventually deliver to someone once conditions are satisfied, or we're holding money that we bill against if we get like a retainer. And
right, like I'm going to put you all this money in here so that when you represent me, you get paid.
So in fact, property management is way more difficult than what we have to do with a trust account, but it's the same concept.
But that's what I was going to say too as far as brokerages go. Brokerages have trust accounts the same way, and they have money that comes in and money that goes out, and they always have to be balanced at a certain number. Like if you put a commission in for $100,000, you're going to have to take that commission out and account for whatever money came out of that account. And it's an operating account and a trust account are two different things. Mm-hmm. But with property management, what you just brought up is that there's so much complexity because it isn't just a commission or one payment in and one payment out. It's literally, I spent $35 paying this water bill. Well, $350 paying this water bill. And I paid this for marketing and I paid this per door to lease it. So do you get a lot of complaints on property management?
We don't get a lot of complaints on property management from the tenant side because the tenant laws in Arkansas are terrible. There basically are no rights for tenants.
Well, we'll get back to habitability.
We've talked about that on a previous episode in November of this year, so a couple months from now. There's a law that kicks in that will help some of that. But from the property management standpoint, it still doesn't, as far as security deposits and stuff like that are most commonly what you get a complaint about. This person won't return my security deposit even though we left the property in perfect condition. They're coming up with things that they say,
boy, isn't that a perspective issue?
Yeah. And so it's all perspective. It's subjective as to whether or not the deposit should be returned.
So the other thing is where there are certain rules about who can manage property and who cannot manage property. Break that down for me.
Well, we get more calls from landlords than anybody.
Right. Trying to evict people.
And a lot of times these are landlords that own the property. They're not actually a property manager, but we do some property management. We represent some property management companies as well. And these companies, like a lot of real estate companies, are both property management companies, but they're also leasing companies. They're actually representing a person that owns property attempting to lease the space for them. And then in turn, after they lease it, they act as the property manager.
Back up. I just realized that that's a total conflict. Really? That's a dual agency situation, essentially, right? Because I'm leasing this, I'm best interest of the seller, but then I'm also trying to get the buyer to come in and trust me to do the right thing and to hold their deposit and do all that stuff. So I'm basically a dual agent.
Yes, but you're not gonna get to the top of that mountain.
Yeah,
there's mega companies that are doing that exact thing.
Well,
it's not gonna happen.
But the other thing is that it just doesn't make, for me, I think that when I think of property manager, I don't think of necessarily an unlicensed entity. I don't think of an owner. When I hear property manager, I think in my mind that that's a professional service, right? But that's not exactly true. You could manage property without a license, correct?
You can, but those rules don't apply when you're managing your own property.
There's the key, guys. If you're managing your own property, you don't need a license.
Or if you're managing the property of, let's say you form an LLC that's a property management company, and you also own a property in another LLC so let's say you and I have common ownership in this other LLC that owns property that our property company manages. That doesn't apply. The rules don't apply there either. It has to be a third party. Now, if you and I and Aaron back here, if we own this property, just you and I have a property management company, then the rules apply. It has to be common ownership.
Then he has to have a license.
No, then you and I have to have the appropriate license in order to manage the property that we own with him.
Oh, because he's a third party to it.
To the ownership property, not to the property management company.
Okay, and that's the difference.
Yeah.
So I've had experience as a property manager in 2 different states, once in Las Vegas, Nevada, which is a whole different thing, and then here in Arkansas. The tenant laws, like you mentioned to and alluded to earlier, we'll get to in a minute as far as the changes go in November, but it's starkly different from the standpoint of a tenant in a different state compared to Arkansas because of our lack of those laws. But what I know from a licensee standpoint is that, in my opinion, correct me if I'm wrong, it's the easiest way to get in trouble, to have a broker's license involved with a property management company, because not only is the trust account an issue, but now you're dealing with tenants. You have people who are going to call and complain and say, I'm not being treated fairly, and or this isn't being done on my property. And as you mentioned before, it's subjective. So they could call, and what does the commission do when somebody calls them, tells them that there's a complaint?
You tell me if someone wants to
file a complaint. If I call the commission and I say my landlord is operating, illegally, it's the first thing they're going to do.
They should tell them file a complaint that tells us what's going on.
And then they're going to investigate
it. And they do an investigation. They go look at the books. And I need to clarify something I said as well. When I say the rules don't apply, if you and I own this company that does the property management of our own company, it doesn't apply to the extent that we have to have an active license.
Or that we're held to the same standard.
You're held to the same standards on the things like making sure you can account for security deposits and money and things like that. You're not held on the same standards of the licensure and the advertising requirements and the marketing requirements and those kinds of things. But as far as keeping up with the money and what happened to it, because this is ultimately other people's money, except for whatever profit you make as a property manager, you have to be able to distinguish all those things, whether you own the property that you're managing or not.
Right.
So it's not across the board. Everything we're talking about doesn't apply if you're doing this for your own property. It's just the things about marketing and having some license attached to it that you register with the real estate commission. Those things don't have to be done.
Well, and I guess that's why I feel like there's so much more liability associated with somebody who does have a license, because at that point you're being held to a standard with how you post something, what you post, where you post it, and then also your reaction to those people who inquire. So if somebody inquires upon you and you're like a real jerk about it, and I'm just saying from personal experience, if somebody inquires or they say something's wrong, and you don't immediately respond in a professional manner, and they go to your licensing authority, you're now being called into question on every single action start to finish, because the real estate commission doesn't go in and investigate a portion of a complaint. They investigate start to finish what's going on in your books and how are you treating your tenancy.
And then if you're a licensee, it's not even...
Fair housing applies.
And it's not even necessarily restricted to only looking at the property management side of it. They're going to look at every transaction that you've brokered, that you've signed off as a licensee on, any of that. They're going to look at all of it. If you can't account for every penny across the board, that's where they really will get you. The real estate commission, in my experience, they come down hard on people that can't account for their trust account. I call it a trust account. It's called something else, I think.
I really think it is just the trust account, because as I remember...
you got to account for that trust account, and you got to have documents that have been reviewed by your broker if you're not a broker. And if you are a broker and you haven't signed off on documents, I've seen they'll hammer those two things really hard.
I'm sorry to interrupt this riveting conversation, but it's time for a word from our sponsor. This episode is sponsored by American Abstract and Title Company. Not only does this place handle most of the real estate transactions that go down in Pulaski County, but they do it with professionalism, and no one has more energy than their fearless leader, Andrew Atkins. If you have any concerns whatsoever about your title work, bring your file over to American Abstract Title and know it's going to close on time and in style. I have used American Abstract Title for more than one transaction in my real estate career, and they are not one of the reasons why I host a show called I Hate Real Estate. Remember, at the end of the day, we don't really hate it, we're actually great at it. So, my friend Andrew Atkins and American Abstract Title is the place for you to close your business. This episode is brought to you by Campbell & Groom's Law Firm. This small law firm has the tenacity to go after the big guy when your HGTV situation doesn't turn out so great. Remember, we started this show for a reason, and these guys know what to do when things turn upside down. Donald Campbell and Kendall Grooms are the Arkansas Trial Lawyers Association Trial Lawyers of the Year for 2019, 20, and I'm pretty sure 21's in the bag. You remember that phone call I made to you one day and said, I don't want to do property management anymore, because here's the thing. I never really wanted to in the first place, but sometimes it does pop up and you get an opportunity to represent somebody else and you're trying to do the right thing. But in my experience, it gets out of hand really quickly because it's not just the trust account. It is all of the treatment and maintenance. And that brings me to the next thing, the agreement. There's going to be a property management agreement, right? And that's going to come between the principal broker and the owner of the property. So really everything that's outlined in that agreement is what the commission's going to investigate, in addition to the trust count. But they're going to look at how the relationship was formed, because if the relationship is between the principal broker and the tenant, that would be one thing. Typically, it's between the principal broker and the landlord. So there's supposed to be a current management agreement on file for every owner for every property that you manage. So you're not supposed to have like a blanket agreement. And then they talk about from there the lease agreement. And what the commission regulation states is squiggly line. I'm just kidding. There's no squiggly lines.
Oh.
It's 10.10a. It says a licensee shall also see that clients and other parties to the transaction with whom the licensee deals receive all copies of all agreements signed by all parties. It's strongly recommended that the licensee obtain written acknowledgement from a buyer or seller that the buyer or seller have received those copies as well. Have you ever had an issue come in where somebody says they don't have an agreement with this person and they don't understand why they're being held to any specific standard?
I don't think so.
Well, you're lucky.
But I know it exists.
I'm sure it does. And there's always a problem with, I mean, in my opinion, I'm a hater when it comes to property management, okay? I hate real estate's title probably directly came off the back of my experience in property management. And I'll take you back real quick just to another state. When I lived in Las Vegas, this is how I really got burned. I was managing what's called the Turnberry Tower, at least a couple of units in there. And the guy that had the penthouse, I hope someday he actually finds this episode and listens to it. What a jerk. Because literally, I'm trying to manage this property. I'm doing the best I can. It's like Thanksgiving Day. This place is a couple $1 million. So it's got a German dishwasher in it that you cannot find the parts for anywhere but Germany. And on Thanksgiving Day, he calls me and literally starts cussing at me because his dishwasher isn't working and his family has just finished Thanksgiving dinner. And by God, he's not washing those dishes by hand. And I was sitting there at 19 years old and thinking like, how am I going to repair a German dishwasher on Thanksgiving Day? I had absolutely no idea what to do, but I'll tell you what happened. I got a complaint filed against me for the mismanagement of property. Granted, it was dismissed and nothing came of it because clearly I had not done anything wrong. But that kind of brings me to the point of why property management is, quite frankly, a pain in the ass, because people can call and make a complaint just like they can on an agent. But you bring property management into it, it's not just about the agreement between the tenant and the landlord. It's about the agreement between the landlord and the management company. And the management company may be over here and have no idea that there's an issue between the landlord and the tenant. And they might only find out through the complaint.
Well, what'll happen then is if it is an issue between the landlord and the tenant, the landlord's going to say, you need to talk to my property management company.
Yeah, they do that. They
do that all the time. Mm-hmm.
What if they are the property management company? Goes back to that same thing, right? And then they're going to have to deal with landlord-tenant laws. Yep. So I'll try not to complain too much about that, and I'll move us on to the most.
I think it's worth complaint.
Well, I think it's frustrating, though, from that standpoint, because a lot of times you want to think about that from the tenant perspective, right? You want to have a habitable home. You want to be able to have a landlord who does what you want them to do. But I think, personally, that the property manager being in between the landlord and the tenant is oftentimes the breakdown in communication. This person has no true loyalty, really. I mean, at the end of the day, to either side. They're trying to manage the property to collect payment for managing the property. So if they don't care how the tenant feels and or they're not relaying a proper message from the landlord to the tenant, there's a lot of confusion there in communication. And it's my experience, you put people in the middle, it's going to usually create some sort of conflict.
That's true. If you're going to manage property, the moral of the story is you've got to have your ducks in a row.
Mm-hmm.
I mean,
and morals.
Yes, and morals. It can't be disorganized. If it's disorganized, it's going to end up bad. It's going to end up in a bad situation.
Well, and that brings us to the most dangerous part we already talked about was trust funds, but now we're going to go actually through this part. So really important if you're thinking about getting into property management as an agent and your license. There is actually a section in here about licensees as well, but it's really important if you're going to get into that you're very careful with this trust account, and we'll jump into that right now. So there's a difference between trust or escrow account, how it's identified at a bank, number one. But the commission regulation, which is 10.8C, no squiggly lines here, sir. A principal broker who receives trust funds shall either maintain a separate trust account or shall have an escrow agent for all such trust funds. It's all I can do not to say this with a British accent. The principal broker of the firm shall be solely responsible and accountable for all trust funds received by the firm, all deposits, all disbursements from the trust account. The principal broker is also responsible and accountable for any funds delivered to an agent selected by the principal broker, but is not responsible for funds delivered to an escrow agent selected by the parties. Except as authorized by regulations 10.8I and 12.2, the trust account shall be non-interest bearing, and the name of the account shall either include trust or escrow and must be located in an institution insured by the FDIC. Do you reconcile your trust account bank statement monthly? Break that down for me in layman terms.
Well, I'm not so sure that the escrow portion of that applies to management companies.
I don't think so.
I think that because 10.8 is
that would mean closing.
Well, the 8s and 10s of the real estate commission's regulations apply to all transactions, but I think that that's specific to a purchase and sale where you're actually closing at a title company that would escrow the funds and hold them. I think that from a property management standpoint, I know it's quoted in the evaluation guide that you've got there, and I could see setting it up with a third party, like an escrow. You would almost want it to be an accountant or something like that, or a bookkeeper that would be this escrow person and not necessarily a title company. That would get kind of strange for a title company to get involved. But essentially what it means is you've got to have a designated account specifically for these trust funds. It has to balance, what did that say at the end? Monthly, reconcile monthly. It has
to reconcile every single month.
It's different than us. In law, it's got to reconcile daily. But, yeah. But monthly is...
No wonder you and Angela have such a good relationship. Yeah.
I think that's
Shout
infrequent.
out EGP.
I think that's infrequent enough, or frequent enough monthly that you would be okay. Because most of your tenants are on a month-to-month tenancy if they don't have a contract in place. I mean, that's the Arkansas law. You've got to give 30 days to terminate. And so within a 30-day period of time that you give a notice of termination, you can go back and reconcile every 30 days, and it's fine.
But I'm curious, and I don't know the answer to this because, of course, I'm always timely. But if somebody, let's say I have a trust account and I reconcile every month on the 30th or 31st, whatever, last day of the month, and I have a tenant who's just is infamous for paying on the 21st with a whole bunch of late fees or whatever. If I don't reconcile that payment into that month because I didn't get to the bank or I was in Dallas for the Razorback game and I come back and then I do it the next month, as long as I reconcile that, is that going to be okay or is that an issue? Okay. Just making sure.
Well, and if the real estate commission shows up in the interim of that saying you've got a complaint filed against you and you haven't reconciled it, it's not a problem as long as it does reconcile.
As long as it's not
if it doesn't reconcile and you haven't reconciled it, then that's where the problem arises.
I like the word reconcile.
I do too. My wife loves reconciling bank accounts.
You know what? Shout out to Carrie and Tally over there. I'm still going to use that name. All trust account bank statements will be reconciled. Not only that, but in writing, and balanced to the total amount of trust funds deposited in the account which have not been dispersed. Mm-hmm. Copies of those reconciliations shall be kept by the broker for at least how many years? Take a guess.
5.
3. Kind of surprising. We have to keep real estate transactions for 5, but property for 3.
Law's 5 as well.
Yeah, it does say.
It's also that's also odd because the statute of limitations in Arkansas on a contractual issue is 5 years.
So that should be 5. It does say at the end for 3 years or for such time as may be required by law, whichever is greater. And if the law that applies is an Arkansas statute, it's 5 years. Okay. So actually, you're right. So do you deposit trust funds only in your trust account? Can anything else go in your trust account?
Shouldn't.
No.
But in theory, in a property management scenario, you're collecting money for somebody else always, because if you're collecting rent for your landlord, every deposit or every rent payment that you receive from a tenant should go into the trust account. The only thing that would move out of the trust account would be if you've got a 10% commission, 10% of all rent payments come to me, or I'm being reimbursed for a maintenance expense that I paid for. Those things could be moved out of the trust account into the operating account, and then whatever amount was due to the landlord would be moved out of that account. Everything else would stay in there.
Right, which is, I'm just going to tell you straight up, that's not how some of the management companies around town are being run.
Because that's just basic business. You want to have money in the trust account to make a repair.
Yeah,
if
just
a
in
repair
case something goes down.
So that you can say, okay, I'm not having to go scrounge for money somewhere else in my operating account to pay for a $2,000 repair or a $5,000 air conditioning unit that needs to be repaired, something like that. You need to have that money set aside. You need to have a rainy day fund in the trust account so that you can have money to reimburse yourself out of it against these properties and charge whoever you're representing, the landlord, charge them for it.
Right.
They're responsible for the expenses, not the management company.
Well, I'm just going to blame the paranoid android for my sidebars today because bink, I just got another one. Okay. I have a friend who manages a property in North Little Rock or owns it. And like, he probably is like, why are you talking about this? But I'm curious because what you just said, like a rainy day fund or having a money handy. Let's say you do have proper insurance on the property and you've got tenants in place. And this might just open up Pandora's box. But I was driving home and this property happens to be located right off the freeway on JFK. As you come off the freeway. Uh-huh. And one day I drove by, somebody had crashed into this thing, and it was a 2-story property that had a deck and a porch on the front. I mean, smashed it. It was all down on the... 2 questions. One, from that perspective, like, could you take the money out of the trust account and start working on that? What if you didn't have it, I guess? But then also, until the insurance comes into play and claims get filed and you get that payout, what kind of funds can you use to start working on it?
I would think that that's under a completely separate provision of the contract.
Well, because my next question is, what about those other tenants?
That's a casualty loss. That's like if the building burns almost. If it's uninhabitable because of this event occurring, the building...
It was inhabitable. They just couldn't hang out on their porch or their deck. There's nothing else wrong.
If that's the case, then it would fall under this. Yeah, you'd have to repair it.
Okay, well then here's my other question. What about the tenants and their right to terminate at that point? Could they just walk away because the property not became uninhabitable but had damage to it they weren't willing to put up with?
It depends on what the rental contract says. The contract between the tenant and the landlord.
Okay. If the deck is removed, you still have to pay your rent. But that being said, this has happened in other...
Usually that they would not have the right to terminate unless there was some kind of condemnation that made the property uninhabitable or unlivable. Right. Or if there was some kind of fire loss that couldn't be repaired within 60 days, something like that.
Yeah, which my experience in Arkansas is that it would have to take a burnout to make a property uninhabitable for the most part.
It varies. Those contractual terms vary greatly depending on
how you wrote it.
Yeah.
So, and that also, segue, what about property management agreements? Do they have to be written in terminology? Like, do you have to write them as an attorney? Is it the unauthorized practice of law to execute a rental agreement with somebody without some sort of licensure or an attorney involved?
Mm-hmm. Yes.
Oh, it is. So you shouldn't be buying your rental agreements at Office Depot?
The only way it's not is if you
own the property.
Individually.
Right. Not in an LLC.
Individually own the property, and you have an individual managing it, and you have an individual renting it. If it's 3 individuals... then you can come up with your own contract.
Okay, so if John Doe rents to Jane Doe, John Doe owns the property and he rents to Jane Doe and then Chad Doe lives there.
That's right.
Then you're okay. But if you at all involve...
If any entity of any kind is involved, that's the unlawful practice of law. Yeah. The unlicensed practice of law. Arkansas law says that an entity cannot represent itself pro se. And thus...
I love the term pro se, which means by yourself.
By yourself, without a lawyer. An entity cannot act in that capacity. So if me as an individual, I have a law license. If Jamie as an individual, if Jamie as an individual wants to represent her company and file something or try to draft a contract, that is not legal. That's not legal.
Okay, well I won't do that. I've had enough experience in property management, first of all, not to get involved with it again. And secondly, to understand that this is actually really serious business. People don't understand that what the real estate commission will come down on you with, you won't be practicing other
people
things.
Do this all the time. This is not just in property management. You have agents that I'll see contracts where they take this other provision. I think it's paragraph 29 or 30.
It's 30.
And they'll do this other, and they'll write out a whole list of terms that the parties have agreed to and different language about what terminates and when something triggers, and that's illegal.
Yeah, it's the unauthorized practice of law. Yes. We're actually covering that on the next episode, so hold back.
All right.
Hold back.
All right.
So moving on to the commission regulation related to funds again, because then I do apologize for taking us off. I was going to ask about, when you own a property and damage happens to it and you have to file insurance, what your rights are to the tenants, and we'll get there in a minute.
Okay.
A principal broker may maintain the broker's funds in a designated trust account only when they're clearly identified as the broker's deposit for only the following purposes. If the bank account where the account is maintained designates a specific minimum balance that must be maintained. So let's say Arvest says you have to have a $100 balance in this account at all times. That's the only thing that's allowed to be in there other than the reconciled funds coming in and out. And then also if the bank account which is maintained requires a service charge to be account, the broker may maintain a reasonable amount to cover that charge. However, the such amount should not exceed a total of 6 months service charges.
Most banks don't charge a service charge against a trust account.
That's because they're great. At least Arvest is. That's who. Shout out.
Yeah.
That's who I use. So it talks about lease agreements showing the amount of security deposits paid by tenants, and are you holding the security deposits on a trust account? This is really important, especially if you're a tenant. Listen clearly. Security deposits made under a rental or lease agreement have to be deposited in the principal broker's trust account, including those deposits made on property owned by any licensee licensed under the principal broker, unless the licensee who owns the property has a written agreement with the tenant, providing that the licensee may keep the security deposit in a separate account, and a copy of that agreement should be furnished to the principal broker by the licensee. So breaking that down, tell me what that, if you're talking to a brand new agent who just got out of school
So a security
hours.
deposit is not income for the property manager, for the landlord, nothing. The security deposit is to cover, like if you check in a hotel, you hear the incidentals. They'll charge your card to make sure you didn't destroy the room. It's the same thing.
They don't charge people enough for that.
Yes. So most agreements will say that the security deposit is not even to be applied as rent in the event that someone doesn't pay rent. Like if you skip a month, you can't just take the security deposit and say, okay, now you're caught up. Now you owe me another security deposit. You can't even do that with it. A security deposit strictly to be used at the end of a contract to determine or for remarketing purposes. A lot of times you'll have remarketing purposes where if someone's moving out in 3 months, you can put a for sale sign, might have to hire somebody to do some advertising or some marketing. You can apply some of that money to it. If you have to paint the inside of the property or change out the carpet, the security deposit can be used for that. If things need to be cleaned, that kind of thing.
Can we just all agree that carpet shouldn't be a thing anymore?
Yeah.
Thank you.
But that's what it's for. The last part of that, I frequently put that in agreements that I draft for property managers or for in just a straight landlord-tenant contract, that the security deposit can be commingled with other funds, that it doesn't have to be held in a trust account. As long as you can account for the fact that the security deposit was received by way of a receipt or an email or whatever it is, some acknowledgement that the security deposit is received.
Some written acknowledgement.
That person that received that security deposit, that landlord or property manager, is responsible for calculating the security deposit, whether in full, a partial, or none of it is to be returned at the end of the contract.
And this is where a lot of people get into it too, like you said, because that subjective nature of this question, and let's segue over there before I go any further.
There's more fights about
we're only on page 5.
Getting a security deposit returned than anything else.
What's the worst? Have you ever seen somebody incur more fees fighting for their security deposit than what they own? Because you're good enough to give them the advice up front?
To tell them.
Yeah.
Don't fight about it.
Don't do this.
Or
it's
go turn
cost
them in
you
at the
more.
real estate commission if you think they're doing something wrong.
Well, that's the easiest way, and let's just full disclaimer right there. The easiest way to get your money's worth as far as investigation and execution of a disciplinary action. Look at me go.
Yeah.
Is going to be through filing a free complaint through the Arkansas Real Estate Commission. And keep me on the stand, Kendall. I'm getting good at this. Yeah. No later than 3 days, by the way, following the execution of the contract by the buyer and the seller. In this case, landlord, lessor, lessee. Correct? Yeah. All trust funds delivered to the principal broker have to be deposited in the trust account within that 3 days or deposited pursuant to a written agreement by them. So the main thing I think with the accounting, and we'll get into kind of further accounting, is that basically you can't be taking money out of this account for any reason other than to make a repair or re-advertise a property, advertise or market, or pay the property manager, but there's not profit in this account really that you're just going to leave in there, and there's going to be a reconciliation every day of everything that comes in and out, right? Do you have any other tips for property managers or people who are self-managing related to their trust account?
No.
Hire an accountant.
It's got to be that it balances.
Yeah.
And if you don't know how to do it, find somebody that does know how to do it.
Yeah, I know
and
a couple
the security
people.
deposit is not profit.
It's not income.
It's not income of any kind.
You have to give it back.
Yes. If you don't use it for a reimbursable expense that you incurred to correct a property issue, change a property issue, or marketing or something along those lines, you have to give it back.
Dang it. Those of you who are trying to say, oh, actually, that property is in horrible condition. It looks exactly the same.
Now, a contract can say that the security deposit can be applied towards rent in certain circumstances.
In the event of non-payment.
And you can contract for that to occur. But it's usually, if I draft a contract like that, it's at the end. If there's rent due at the end that's not paid and the contract becomes terminated, we'll take the security deposit and apply it towards any money that's owed at the back end.
That's not in the automatic agreement.
But that's not automatically. You have to have that in some kind of a contract.
And you can't write it in on item 30.
No, you can't.
I can't wait to get to that. I'm so excited.
Yeah.
So here comes the part everyone's going to get scared about, okay? I don't know if you guys know this, but record maintenance is a thing. And that means that you have to maintain a file containing invoices for every expense that has been charged to the owner for the maintenance of the property. In fact, it says all records required by Regulation 10.7 shall be maintained by the principal broker for 3 years or such time as may be required by law. 5, whichever is greater, and shall be open to inspection by and made available to the investigative staff of the commission at the firm's office or other location designated by the commission. All of them may be maintained in electronic form, provided that a copy of the records can be produced by this regulation. So your firm or any entity related to your firm, if they profit from maintenance activities performed on the properties they manage, is that legal?
You're talking about charging like a markup for maintenance purposes?
Yeah. The question they ask is, do you or does your firm or anyone or any entity related to you or your firm profit from maintenance activities performed on properties you manage?
Shouldn't.
Nope. You shouldn't. It says, are all profits received by you, your firm, or anyone or any entity... I'm going downhill quickly. Related to you or your firm, disclosed in writing to the owner of the property on which services are rendered. It's going to be Commission 8.5.
Yep. And what that means to me is if you buy a 99-cent light bulb to change out something on a property that you're managing and you deduct that from an account as a reimbursement expense, you not only have to show it in the bank account, you have to show the receipt where you bought the 99-cent light bulb.
All right, this is where things get hairy because it comes back to like when I talked about at the beginning that you have this free recourse to go to the real estate commission and have something investigated with your property manager. You can really start a big problem here with this. Now, this is not a PSA for you to go complain about your landlord, okay? If they're treating you nice, treat them nice. But when it comes down to the management of property, I know for a fact, not trying to be rude to you guys out here, but there's not a whole lot of fantastic record keeping that goes on when something goes wrong at a property, because sometimes something bursts, like a pipe will burst and somebody will go out there and start fixing it and the plumber will go, and there's going to be things like the extra hours by the employee or some sort of tool or pipe or something that gets done by the plumber and perhaps gets paid, let's say, by the escrow account. But then there's this ancillary charge or this other contract that gets executed where you make a payment. And technically, if the commission was to come in on that you would be in a lot of trouble because you didn't have a receipt for that ancillary payment that you made to fix something or have a tool, right?
Yep.
It kind of scares me just because I know from experience, keeping track of those is very difficult, and especially when you have multiple doors. So it's one thing when you're talking about one house.
It also becomes more difficult when you have multiple employees that are handling properties, because if you're doing it yourself, you can count on yourself to make sure that a receipt gets scanned into the system. And
no, I can't.
In general,
I know.
If you really want to undertake this,
I know
you can be responsible for yourself,
right?
But you're, as a broker or the person whose license is on it, you're responsible for everybody working for you too.
The other thing is,
so if someone accidentally trashes a receipt one day at lunch when they're cleaning out their car, then you've lost that receipt.
The other part, though, is you really just hit it on the head right there. Those of you with broker's licenses. It's every agent that's managing a property underneath you, every single agent and every property and every document associated with that and every receipt for every repair. If it's not neat and clean,
even if
you're
you don't
open
know
for issues.
Even if you don't know, if you're the broker, if you're the actual licensed broker with your name on it, if something happens, even if you don't know about it, had nothing to do with it, never even knew you managed this property, you're on the hook for it.
Well, first of all, you better know you managed it because you signed the agreement.
But that's how far it goes. Even if you know, even if you don't know, even if the only thing you've ever done is sign the agreement so that someone else can handle management of the property.
Because you don't have to go to your broker and say, the water pipe burst at this location and I had it fixed by a plumber. That has nothing to do with the broker. The broker does not care past that point. They sign the agreement. They assume that you are acting on their best interest, the firm's best interest, and that your property...
They might approve the transaction or something like that.
Maybe. But maybe, like in my situation, if I'm a principal broker and I have somebody who works for me and has permission, because that's another thing you need to have is written permission for somebody without a license to show property, to execute in any way a real estate service, they have to at least have your permission in writing to go and show a property, to go and open a door. Now, if they have that and they go and they do it and they, I don't know, let's say they can't get in the door, so they call a locksmith and the locksmith comes and he changes the locks and they get in there and he doesn't ever tell you about it, or he doesn't update you, or he says, here's a new key, I had it rekeyed, but he doesn't give you a receipt. I mean, if something comes down, you're up the paddle without a creek. I mean, up the creek without a paddle, right? So basically, the commission's regulation states, I like how I'm quoting this, when acting as an agent in the sale or management of property, a licensee shall not accept any commission, rebate, profit, payment, compensation, or any valuable consideration from any source in connection with the property without a full written disclosure to the party represented by the licensee. So that means you're supposed to tell your broker about every single little thing you do. Guys,
It doesn't happen.
No, it doesn't. I feel like a jerk sometimes on this show, but we're haters, right? That was the idea, was to point out the things where people can get really hurt, because this actually affects brokers, I think, more often than anything. And I know in my experience, I actually pulled and shied away from property management on a permanent basis because, to be totally honest with you, the stress level of doing it well was too much for me. And I can handle a lot of stress, but I remember calling you like every day, like, is this right? Is that right? Because if you mess up on this, you can actually take your license and your broker's license and your agency and everything that you've built and completely lose it over little record keeping issues. You think record keeping is a big deal in brokerage.
Well, and there's a problem here for a landlord too, because
you get tied up in the middle.
Well, you can. Arkansas law is very clear about a third party like a landlord or a corporate officer being held liable when they're involved in the day-to-day transactions, when they're involved in the decision-making of the company. If you're not hands-off, then you can be held personally responsible if something goes wrong. So in my experience, let's say that landlord has an LLC that owns this property and they hire a property manager. If they're hands-off and they actually let the property manager manage that property and they just get a check every month, if something happens at the property that was the management company's fault, something neglects to get repaired, and somebody gets injured or killed, the landlord doesn't have it. They may get sued, but they don't have any liability in that. However, if the landlord catches wind that
both of us are smiling like, and then this happened,
that the property manager is not doing something or is deficient at something or has caused some problem, and the landlord just stands there and watches from the side knowing that something's happened, there's a good argument that could be made for landlord liability if something else occurs beyond that causes additional damage or hurts somebody else. And that's where it becomes more difficult. You really have to trust your property management company.
You should trust your property management company also for the plain fact that these people are just trying to find a habitable, nice place to live, and they just want peace of mind like everyone else who goes home at night. And you should be ensuring that if you're going to own property and have the privilege of renting it to other people, you should have the moral fiber to back that up with appropriate action. And so that being said, let's answer the question of what happens when something goes horribly wrong. Let's say that you own a property, you're out of state, there's a fight at a club, there's someone gets run over on your property, a dog bites somebody. What happens in that situation if you're a hands-off landlord and you're told, hey, the dog next door seems really aggressive, I'm kind of nervous about him, it's fine, that's the neighbor's dog, don't worry about it. Next week, dog gets somehow onto the property and bites the tenant. Previous story. Yeah. And that's not funny. And then you find out, you just had to be there. You find out, okay, the landlord actually knew that there was a Akita or a pit bull next door, and they got all crazy. And I knew about it, and I told them, don't worry about it. But then the fence failed or something happened, and the tenant was attacked. What are the rights of the tenant in that situation?
There could be responsibility to both. I can envision
Personal liability.
I can envision a scenario where the landlord and the property management company would have fault.
Probably because property management probably should have.
I mean, there's a lot of nuanced facts that go on here that can go on in a situation.
Here comes
like
a lawyer who wants all the facts.
But,
sorry.
Yeah. Want some proof, right?
Yeah.
But I can envision a scenario where both can be held responsible for the acts. Right. For the damage.
You can probably envision scenarios that I would not ever want to think about with your past in this industry. But anyways, from an agency representation disclosure, and we'll move on to that because there are some agent-owned property things that I want to talk about, because a lot of times agents feel like, okay, I'm a licensed professional. I can manage my own property. I know how this works. but they're not actually thinking about all the things we talked about today with the repercussions of how those agreements get executed. And like you said, the unauthorized practice of law, writing their own lease agreement. Mm-hmm. There are lease agreements that are drafted through the ARA. We know the guy came up with those. He's pretty cool. When you have those kind of agreements, it kind of is ironclad about a lot of different things. However, you cannot just add ancillary terms to those without the approval of a law professional, correct?
Correct.
Okay, so then moving forward, the commission regulation that states, as far as a licensee goes, says that a copy of all of these agreements, including the security deposit and licensee's separate account, if applicable, shall be furnished to the principal broker by the licensee. And the property management regulation definition in 10.18, which is right behind it, talks about all of the things that you have to understand about being an agent-owned property. So there are like 5 of them. One of them is an audit trail. Do you know what that is?
It's what we've been talking about.
That's a documented history.
Receipts, bank accounts.
And the occupant is a person.
I mean, the audit would include the contracts you have with people. It would include all documents involved in the rental, leasing, whatever it may be.
It says every single financial transaction by which the transaction can be traced to its source. You have to have a documented history to go back to the source of every single dollar that comes in and out of the property. Mm-hmm. There's a difference between an occupant and a tenant. Do we know what that is? This one actually surprised me.
I think that the tenant would, in my mind, the tenant would be the person that actually signed a lease, and an occupant would be someone there. It could be a minor person, could be another family member living there.
It means a person who rents the property on a nightly basis.
Is an occupant?
I thought that was kind of cool.
I wouldn't have guessed that. I've never heard that term.
I was going to say, maybe not even cool, but odd that this is in here. It says
because
property
there's
management
laws
division.
where we have to give notice to the occupant at a certain address, and that's to all other persons that are there other than the person that has a contractual right to be there.
So that's technically probably what that should be corrected to say, because it says
it doesn't have to be. I mean, if you
say nothing needs to be corrected. Good job, Racy.
If you define it, it's okay.
Right, and it just says a person who rents the property on a nightly basis. So my son is 14, and he would be an occupant of my home because he's paying rent with his good attitude. The second he stops with it, I'm just kidding. Property manager is a licensed principal broker. This is the definition. The definition: a property manager is a licensed principal broker or designated executive broker who performs property management activities pursuant to ACA squiggly line 17-42103 parentheses 9. You know that one by heart? I'm just kidding. But this section, and this is the last thing, this whole property management thing kind of owns at the end as far as these definition goes. It says, this section does not apply to any residential property management program operated or regulated by a federal or state act or agency, which includes specific record-keeping requirements that the commission determines are substantially equivalent to or greater than that required by this section. What exactly does that mean?
I've never read that one before, I don't think, but it sounds to me like if you've got the government owns properties that they're not subject to that management.
Like housing.
Yes.
Okay. So, and housing's another thing too. As a whole, you have a certain level of quality you're supposed to keep those properties too. So property management agreements we know about, tenant agreements. Let's see what else is in here.
You said something interesting earlier too, that when we talked about how these rules don't apply, you've got to have a contract to show the property, to show an apartment that you may be renting. You don't if you're the owner manager. If you own the property and you're managing the property, like the example we talked about, you can go open you own it. You can go open the doors anytime you want to.
But I can't be a principal broker operating with an owner and allow the owner,
third party owner.
Well, and let's say that I have an owner and I'm the property manager and the owner has a personal assistant and the owner sends the personal assistant to show the property. That's not legal.
Not without a written agreement in place with approval by the broker for that person to show. Because the brokers...
Shocker, everybody who's showing property like that. I'm just going to straight up say it. I don't care if you're an employee.
If you've got an employee, if you've got a manager that is at a property in an office, because a lot of these properties will have an office where someone will be a manager. It makes it easier. Sure it does. That person does not have the authority to show any of those units at the property absent specific approval in writing from the principal broker, because the principal broker's license is the one that's on the line.
This is the part that I want you to understand if you're an agent or a broker, and you can hate on me until forever. I do not care. one day when you're sitting in front of the real estate commission, you're going to be like, damn it, I should have listened to that episode a little bit closer, because I'm sorry about my language today. It's like black fingernails and feeling very angsty because I knew property management was on the table. The thing is about it, you can lose your license allowing somebody to open a door, and you think, well, I'm not going to get caught. What if that tenant actually leases that property and then something happens with the property and the tenant gets pulled in and the real estate commission asks them the question, who showed you the property?
The real estate commission is going to come in and say, all right, where's your contract? Who gave you this contract? What did you see the first time you went with the property? Who was there is the question they're going to ask. Mm-hmm. And when they say, oh, it was this guy who...
It was Kendall.
It was this guy that has an office down the hall from where this property was. And they look across the table at the broker and they say, does this guy have a written agreement from you allowing him to show the property? And the broker says, what are you talking about? I didn't know I had to have that. And now you're going down a slippery slope.
And I'm going to tell you point blank, totally 100% honest as I can be, that was something I learned because I sat down and read this thing, which if you're wondering what this is, it's the self-evaluation guide available on the Real Estate Commission website. You go to aric.gov, go to Forms and Publications. It's listed as the Property Management Self-Evaluation Guide. They also have that for brokers.
And even if you're not in Arkansas, there's probably something similar in any other state.
It's probably worse in another state. And when I say worse, I mean more complex. And so we're about to...
Arkansas is like 50th in tenant rights out of 50. So.
You know what? We're number one in rice production, okay?
There you go.
We have good things here. Also, our football team is whooping everybody. Did you see this funny post where they said, oh, it's National Daughters Day? And then it was like UT and A&M, love your daddy, Arkansas. Sorry, I had to say it. I was very proud. Anyways, back to property management. We managed
Football
Texas.
is much more fun than property management.
We managed their property pretty well this weekend.
Yes, we did.
But anyways, the state of Texas is going to sue me. Yeah. All this being said, you have to have a property management tenant ledger. You need to look at the self-evaluation thing because that's really what surprised me about it. I'll be totally honest. I thought, if I have a property management company.
We haven't even talked about the ledger you just mentioned. It actually specifically mentions that you have to have a ledger in the property management section, does it not?
It does. We're going to go ahead and stay on it then. 10.22 is what it is. Page 11 of the self-evaluation says a property manager must prepare and maintain at least one separate owner's ledger for each property management agreement. So you're talking about you have multiple properties. You're going to have a ledger for each one of them. It says if the property is utilized for nightly rentals, Airbnb, a separate ledger account must be maintained for that property. Each occupant of the property must be identified, including the dates of occupancy and the amounts paid. I wonder if all of our Airbnbs around town have a separate ledger. I'm guessing probably not. If a property manager has access to a separate banking or escrow account owned or controlled by the property owner pursuant to a property management agreement, the property manager may maintain either a record of receipts or disbursements or check register in lieu of the owner's ledgers. Also must contain the property manager's name, identification of the property being managed, and the following information: the amount of fund received, the purpose of the funds, the check number, cash receipt, or unique series of letters or numbers that establish an audit trail, the date they were deposited, the balance of each recorded entry. I could go on all the way through 5, 6, 7, 8, 9, 10. There's like 15 items on here. It says if more than one property is managed for a property owner, each entry for deposit or disbursement must identify the applicable property rather than just the owner. And if a property management agreement with an owner allows the manager to use funds collected for one property to apply to expenses of another owned by the same owner, an overall compilation and accounting shall be prepared for the owner. At minimum, once each month, a report showing all receipts and disbursements for the account of the owner must be provided to the owner. A copy of the electronic version of each support will be available through the record system.
That goes back to what we've talked about the whole time. It's all about the details. It has to be highly organized. Highly organized.
I'm just going to be straight with you. I don't know a lot of property managers who are highly organized.
I would be willing to bet that there's not a property manager in the state accomplishing all of those items.
Yeah, and if they are, please call us. We'd like to represent you.
Now, with a ledger, I don't want to get off on the actual term because the term ledger is strange.
Makes me think of a notebook
going
in and out.
We don't use ledgers anymore. A ledger can be something digital. It can be something electronic.
We use computers.
Yeah, it can be something. QuickBooks will create an account is what they're called in QuickBooks as long as it's traceable. And I actually like what it used. It talked about if it doesn't have some designation of traceable like the address, you can actually use a series of numbers and letters that you put on every document. So I see this a lot in the law. You'll have these control numbers at the bottom of documents that law firms draft. A lot of the really big law firms use.
Like handling groups?
No, we don't use a document creation system like that. They'll use a document creation system that generates a control number in the bottom. So that control number, you'll have like .001 at the end or .002, so you can trace what draft it is, how many times it's been revised. But the same thing would apply here. You can create a control number that goes on a document associated with each property. It's probably more difficult than just putting the property address on there, but that even says
sometimes
it has
the property address has 30
units.
units.
That's what I'm saying. That says it has to designate the property address and the property owner if you don't have a control number.
I mean, this whole thing
you could have a 30 unit condo complex, and 26 of those properties be owned by 26 different owners, and 4 of them be owned by the same owner. And if you are the property manager for 10 of the properties, including those 4 owned by one person, you can't just say
those 4.
It's at 300 River Market Drive. You can't do that. It's not gonna.
And it has to.
You can't
identify.
You cannot trace it back to which. So then, if you start piling a whole bunch of receipts in at 300 River Market Drive, you can't determine which one was for which unit.
Well, the other part is too, like it said, you could move, like, okay, if Unit A has a repair that needs to be done, you could move funds from B to A to do that if you're using it for the same owner. But again, has to be in writing, has to be on file,
and has to be reconciled.
There are tenant ledgers also. Just because we went into ledgers, we're going to go all the way. It says
I've heard that called a rent roll too, but a lot of times that'll be a rent roll for multiple properties all in one place that shows the total profit and not necessarily what the maintenance and expenses were.
I'm going to be straight with you. I don't like rent rolls. I don't like them because of this, because you give people a whole list of who lives there. You're like, here, Jamie Taylor lives here. Here's her address. Here's her phone number. This is when she signed her lease. And although that's not like all my personal information.
Paying every month.
Exactly. And I just, for some reason, I just sold an apartment complex, which I am not managing. But I sold the actual complex. Now that it's under contract, the buyer's like, can I have a list of tenants? And, just in the back of my mind, I'm like, fair housing, like, can't they judge somebody based on like, oh, their phone number, their name, their income, whatever? Like, they could essentially look at that and make a decision whether to buy the property or not based on the rent roll. I think that that's ridiculous. I think that information should be confidential, don't you?
No.
Fine. We can disagree.
I think that's part
on
of the
small
assessment.
Things.
You have the right, if you don't like the name of someone living at a property, you have the right not to buy the property because of that.
That's dumb.
It is dumb, but you have that right.
I know. Well, you know what? We have lots of rights.
There's people that are racist, as you know.
I know, but I think that that's ridiculous in the sense that like it cuts. So that would never fly on a real estate contract because fair housing would apply. And if somebody said, I don't like that name because XYZ, then you would be like, okay, well, that's a violation of fair housing.
They would find another reason to terminate.
Yeah.
But
maybe they're dumb.
Could be.
So anyway, property management tenant ledgers are also something that contains the tenant name, legal description, physical address of the property sufficient to distinguish it from no other rental units like the condos you mentioned, or a unique series of letters and numbers that establishes an audit trail. All of the same thing with the funds, all of the same thing, purpose of disbursement. It says in lieu of an individual tenant ledger, a property manager may prepare and maintain a separate record of the receipt of funds from prospective tenants who do not become tenants after such payment. So this would be application fees, essentially, right?
Yeah, you can charge those.
Yeah.
Processing fee
and the amount of the security deposit.
Well, sometimes that money is used as well. There's companies that run background searches on people. They check credit scores. So sometimes the application fee is actually not just a profit because you're applying to live here. It's used for things to determine certain levels because a property manager may have a requirement in the contract of
background check.
These people that you're renting to have to be able to make the monthly rental payments.
Right.
You can run a credit score. You
verify their income.
There's plenty of people out there that are registered sex offenders.
True.
And you may have something that says in your contract that this apartment complex may not have anyone living here that's a registered sex offender.
Well, I can tell you from experience.
And that's not discriminatory under the law. You can have that. And so if someone has to charge a $100 application fee because they want to run a $50 background check and a $50 credit check on somebody to determine if they're a sex offender or if their credit is 50 on the scale and they've already defaulted at 9 additional apartment complexes where they rented, then that's part of the reason why an application fee is charged.
Well, and I just also on that note would like to mention as a parent that was something I was very comforted to hear, and really you should be, but I actually had this happen one time at a unit I was managing. Was we learned that a tenant on a property we had purchased, and when I say we, when the person I was working for purchased it, realized that one of the tenants, because he went in and was like, okay, I'm going to take over this property, I want to know who lives here, and started running background checks on everybody there, and in that process found that he was a registered sex offender who had not disclosed that, which is totally illegal, as you know. But that's the thing about it, as a landlord, know that that person by law has to do this on every door and say, hi, I'm a registered sex offender and I live next door / across the complex. Hope you're comfortable. And when that happens, you're probably going to lose a percentage of your tenants. And so and I hate to say that because some, maybe, I don't know. Actually, I don't hate to say that.
You're going to lose female tenants and you're going to lose tenants with kids.
Mm-hmm. Unless you're a female sex offender, and then you're not going to lose anybody. I'm just kidding. I'm just kidding. That's not funny.
It's not funny, but it's probably true.
Yeah, because, but anyways, long story short, when it comes down to reference materials, basically, there is no shortage of information related to property management, and you can find it on the Real Estate Commission website. It is free. The big thing that really gets me about this, and that I think is a great subject for I Hate Real Estate, is that it's the basis of a lot of complaints. It's something that people really struggle with, and now
it's difficult to do.
And it's not just apartments. We have to remember that this is commercial property. This is triple net leasing.
Commercial apartments. If you rent a single family house to somebody.
Yes. If you have a factory
where people can get hurt. My grandpa at one point in time owned over 100 rental houses, and he did them himself. He didn't have a property management company.
I wish we met before he sold
them. But, the property, if he'd hired a property management company, that's all single family homes. A couple of them were duplexes or triplexes, but you've got to manage those the same way.
I have a guy who's a friend of mine who I know he listens to the show, so hey, buddy. But he probably owns, I'd say 225, 230 individual properties. And I can tell you right now that I'm sorry, in the back of my mind, I'm like, there's a recording sign on the door. At the end of the day, I know that his full-time job is managing his properties. He does nothing else because those properties and that amount of activity associated, it should be his full-time job. So if property management is not your full-time job and it's not something you want to do with quality and execution above what you're expected to do, which is already way up here, don't get involved with it, because all you're doing is becoming a middleman between two people who have opposite interests. I'm trying to pay less, I'm trying to profit, and then I got somebody in the middle who's collecting off the top, who doesn't really want to provide the ample service that the tenant needs to get a happy, wonderful, sustainable place to live. So,
and if you're listening to this and you're trying to set up a property management company or trying to fix what's going on with your property management company, who do you call?
Campbell and Grooms.
Or Jamie. You can call either one of us.
Oh, no. Don't call me about property management. No. I love you very much, and you're a great friend. But don't call me about property management.
On this particular issue, we're not going to call Jamie.
No. Sorry, you can call me on anything but my black
fingernails. We have all these promos out there that are fixing to be saying, you can call us about anything, and Jamie's already said, no, you can't.
When you say us, you mean Campbell and Grooms, because they will do a great job, and they might get you out of a pinch if you really screw up, because they can help you tell the truth and do a better job. But when it comes down to property management, don't call me. You can call me to expert witness you, or you can call me to get you in connection with Kindle. But yeah, you're right. Go ahead and rule on this.
We can't call you to do the bookkeeping?
No. Actually, shout out. You can call EGP, because either that or Carrie and Tally, which don't put her in that situation. She doesn't deserve that.
No.
But EGP has done an incredible job for me, and they will literally, every penny, they're in a situation where they know what's going on. And I would recommend that if you're going to manage property, from my personal experience, protect your broker's license with all you have by making sure that every single property under your license is managed effectively and properly by an agent who has moral fiber and is really interested in the opportunity to provide housing to another person who isn't able to purchase property. Secondly, hire an attorney. Ask him questions. Make sure you ask to put clauses into your statements. When we talk about the bill of sale and things like that outside of contracts shortly, we're going to really, really understand how important it is to not be practicing law and or giving financial advice. So it just kind of comes down to, I have enough experience with this one that the end of this ruling is going to be, Jamie Taylor is not going to help you with property management. She will, however, direct you to the proper authorities as needed.
So what are we going to rule?
We're going to rule that
property management is hard.
Yes.
And we're going to rule that Jamie's going to learn how to do property management bookkeeping.
No, we're going to.
That one's
He's
over.
not listening.
That one's
I have
overruled.
an unruly
No,
objection.
I'm just messing with you. Yes.
Objection.
Yes.
This is what we're going to rule. Don't manage property unless you're going to manage the property. Hey guys, we'll see you on the next episode of I Hate Real Estate. We're out.
Bye.
Go Hogs.